In the UK financial sector, one specific job carries risks that extend far beyond a standard corporate reprimand or a hit to the bottom line. The Money Laundering Reporting Officer, or MLRO, is the single most dangerous seat you can occupy in a regulated firm. An MLRO is a mandated senior executive responsible for establishing and enforcing a firm's anti-financial crime framework. The severity of this role is anchored in the Proceeds of Crime Act, known as POCA. POCA is the primary UK legislation that defines criminal offenses related to money laundering and the recovery of illicit assets. Under this law, an MLRO who fails to report suspicious activity realistically faces up to 5 years in prison, alongside entirely unlimited personal financial fines. If a regulatory failure occurs, the person in that chair cannot hide behind the corporate veil. Unlike other executive positions where the company absorbs the legal blow, the liability here is strictly individual and entirely inescapable. This is why navigating this landscape requires specialized protection. Enter compliance consultant, widely known in the industry as the compliance doctor. They act as the premier shield against these specific catastrophic regulatory threats. Appointing an MLRO is never a ceremonial checkbox exercise to satisfy an auditor. It is a massive, high-stakes transfer of legal jeopardy directly onto the shoulders of a single human being. To understand how firms get this wrong, we have to look at the rules set by the Financial Conduct Authority, or FCA. The FCA is the independent regulatory body that oversees financial services firms and markets in the UK. They designate the MLRO role as an SMF-17. SMF-17 stands for Senior Management Function 17, which is the specific regulatory tag given to the individual holding personal accountability for anti-money laundering controls. The FCA's structural requirement is absolute. Whoever holds that SMF-17 title must be a fully empowered, senior decision-maker who wields genuine, unquestioned authority over the business operations. Yet startups and established firms alike make a fatal error. They hand the SMF-17 title to an executive who is already overworked, treating this massive legal obligation as a secondary side hustle. This staffing error creates an immediate compliance vacuum. The acting MLRO simply lacks the dedicated hours to monitor the framework, and worse, they lack the structural power required to halt a highly profitable but risky commercial transaction. A nominal MLRO, someone who holds the title in name only but exercises no real operational authority, is a glaring structural weakness. FCA supervisory teams are highly trained to identify and systematically dismantle these exact setups. The immense complexity of this role stems from the fact that the MLRO is doing two completely distinct legal jobs at the exact same time. Both must be balanced perfectly. The first persona is the nominated officer. This is a reactive investigative function. Under POCA, the nominated officer acts as a central hub, receiving internal disclosures and warning signals of suspected financial crime directly from the firm's employees. They must evaluate every single internal report on its specific merits. The MLRO then makes the critical decision on whether the evidence meets the threshold to be escalated into an external suspicious activity report, or SAR. A SAR is an official alert submitted to law enforcement detailing known or suspected money laundering. Those external SARs go straight to the National Crime Agency, or NCA. The NCA is the UK's designated financial intelligence unit, responsible for leading the national fight against serious and organized crime. The second persona is the compliance function. Here, the MLRO acts as a proactive architect. They are tasked with continuously building, maintaining, and defending the firm's overarching anti-money laundering framework across all departments. Conflating these two personas is incredibly dangerous. If an MLRO focuses only on firing off reactive reports to the NCA while ignoring the proactive framework building, they leave the firm legally exposed on two fronts simultaneously. The daily volume of proactive responsibilities is staggering. It begins with authoring and then constantly updating a live firm-wide risk assessment based on ever-shifting global threats. Then comes the strict enforcement of customer due diligence, or CDD. CDD is the mandatory process of identifying and verifying exactly who a client is before doing business with them. If a client is a politically exposed person, or PEP, the MLRO must trigger enhanced due diligence, or EDD. A PEP is an individual holding a prominent public position, presenting a statistically higher risk for corruption, while EDD is the rigorous, elevated background check required to clear them. But the most treacherous operational mechanism the MLRO manages is the DAML consent regime. DAML stands for Defense Against Money Laundering, which is a formal legal request made to the NCA seeking explicit permission to proceed with a transaction that involves suspected criminal property. This creates a severe catch-22. The MLRO must freeze the client's transaction and ask the NCA for permission to proceed. If the NCA doesn't immediately refuse, it triggers a highly tense, mandatory 31-day moratorium period where the money simply cannot move. Here is the trap. Alerting the client to why their money is frozen is called tipping off. Tipping off is a criminal offense. The MLRO must perfectly manage an increasingly angry commercial relationship under extreme legal pressure without ever revealing the truth. To survive this execution trap, the MLRO has to operate as part lawyer, part investigator, and part diplomat. It is an impossible burden for an executive trying to manage this as a side hustle. Let's look at this from the regulator's perspective. When the FCA conducts their thematic reviews and site visits, they actively hunt for specific administrative failures. The symptoms of a failing framework are obvious to an auditor: outdated risk assessments that don't match the current business, generic boilerplate policies copied from the internet, and a total lack of bespoke, relevant staff training. The most fatal administrative error they look for is an undocumented SAR decision. If an MLRO evaluates an internal report and decides not to file a SAR, but fails to document their reasoning, that decision is completely indefensible during a formal investigation. A firm does not need to be actively laundering criminal money to face catastrophic penalties. They merely have to fail at properly documenting their prevention efforts. There is a strategic lifeline. The FCA actively permits firms to outsource the MLRO function to external specialists, provided those specialists are granted the proper internal authority and access to data. This is the practical solution offered by Compliance Consultant. Leveraging over 25 years of specialized experience, they step in to serve as a firm's fully outsourced SMF-17 approved MLRO. They provide comprehensive governance reviews, execute deep dive AML audits, and handle the grueling ongoing regulatory risk management, preventing catastrophic failure before it starts. Do not wait for an FCA intervention to find out your framework is failing. Make compliance work for you. Call 0800-689-0190 or book a discovery call today to secure your firm's future.